All right. Well, thank you everyone for logging on today for a virtual stakeholder meeting. It's a joint stakeholder meeting between the Office of Public School Construction and the California School Finance Authority. Just to let everyone know, we do have the stakeholder meeting here on Zoom. There are also 2 physical locations where stakeholders can come provide public comment. If you are watching this and trying to come provide public comment, if you're coming to the Ziggurat building in West Sacramento, there is a sign in the 6th floor lobby telling you how to be led into the building. But for everyone else, the way that we will do participant feedback is through the Zoom functions. So there are some reaction functions down there. You're going to just raise your hand and we can just have folks speak the comments. If you would prefer to use the chat function in Zoom, you can do that as well. But we can unmute if it gets to that point and that's where we would love your feedback. So whatever it takes to hear that conversation, that is actually the focus of this meeting. On the website, we have posted the item that we are planning to discuss for this meeting. What we are specifically talking about today are proposed regulation changes for both the school facility program regulations and the California School Finance Authority regulations for a specific aspect of the charter school facilities program, which is the state bond funded program. It had $500 million most recently in Prop 51. It's been funded since Prop 47 each time. To provide charter schools with facilities. And so the program's been around for, 18 years now, roughly, since 2002. And we've had regulations in place that address what happens if somebody that received this funding for charter school facilities, if that charter school is no longer using the facility. There are succession provisions that are provided in the statute, and they're reflected in the OPSC regulations and the CSFA regulations. So those are the regulations we're talking about today, is exactly how we're going to identify a successor charter school. So that's the topic. So if you're signed on for that, you're in the right place. And before we go much further, I wanted to take a second here to introduce some of our state staff, and then we actually have a small group. We do have some call-ins. We are actually getting a little bit bigger, Katrina. I think we're at around 24, but we can also do introductions to the group. But I will start. I'm Barbara Kampminer. I'm the Deputy Executive Officer with the Office of Public School Construction. I've been involved in the charter school program since I started with OPSC back in 2003, so in various capacities. And then we also have Erin Canine here with us with the Office of Public School Construction as well. Many of you, if you are in the charter program, have talked to Erin. She is our lead analyst for this program. You will notice a few other OPSC faces or names on here that are helping us in supporting the stakeholder meeting today. And Katrina, I will turn it over to you to continue introductions.
Thanks, Barbara. Thanks, Erin. Thanks, Michael, and everyone else on the OPSC side. My name is Katrina Johansson, and I'm the Executive Director of the California School Finance Authority. I've been in this job since 2000. When this program was just an idea and a pilot program, a $100 million pilot program back in 2002, is when we developed our regulations, as Barbara mentioned. We now have a $1.4 billion revolving loan fund. We've been administering this program for almost 19 years. So we are reaching program where schools are no longer need the facility for various reasons, and while reflecting on our regulations, we wanted to provide a little more clarity from what is stated in the law and what's in our regulations. So as most of you know or don't know, there are several fact patterns under this program. So we're going to try and address any questions related to a standalone facility versus a district facility. Maybe a joint project with the district. So, we're here to answer any questions and get your feedback on the best way to move forward on our regulations. So this is the first time that we've jointly done a stakeholder meeting like this. We have a very strong working relationship with OPSC. So we're glad you can all join us today. So with that, I wanted to introduce Tom Deere. Tom's on the phone. And Michael.
Hello, everyone.
from CSFA. Michael is also helping administer the CSFP program. So for those of you that are currently in the program or want to gain access to the program, Michael would be the person that you would communicate with related to the financial soundness determination that the CSFA board undertakes. Thanks, Barbara.
Great, thank you. So just a little bit about the format for today. And actually, as we work through these, we do have another stakeholder meeting scheduled for a week from tomorrow. So March 5th, we have a follow-up stakeholder meeting. So we will be taking feedback today. Typically in the stakeholder meetings, for those of you that have participated with us before, we don't make any decisions in these meetings because we often need time to evaluate the comments that we hear. So we'll be taking the feedback that we get from all of you today and amending regulations if necessary, looking into the suggestions that are made today, and then we will attempt to turn around a new item in time for that March 5th stakeholder meeting as well. Just kind of depends on what we get today on the timelines for that. So I will say we got this item out, I think about a week in advance of this meeting. Given the tight time frames, we're looking at a couple days in advance of the next meeting. So, and as far as turning that around, just again, depends on what we get today. So this is not your last opportunity to comment today. If something comes to you after we get off the line, then you can feel free to email or join us at the next stakeholder meeting next week. And then we are, depending on how things go, we are both agencies are targeting their March boards at the current moment. So what we'll do today is we're going to walk through the item that was posted and kind of give you guys all the background on the changes that have been incorporated in this draft document, and then see what you think and see what what's working, what's not working, and then we'll give you the majority of the time to talk. So with that, I am going to ask Michael to share his screen with the item, please. Thank you. And actually, if you, we can stay there for just a second. So one of the things that we wanted to highlight from the state perspective, which you can see kind of at the bottom there, page 1 in our cover, as we've mentioned, this is just one piece of the regulations. So there's already some broader regulation language in there that talks about what happens when a charter school no longer needs its facilities for charter school purposes. And it all comes down to the intent of this funding, right? So the intent of the funding is primarily to have charter schools have access to these facilities. So what the statute lays out and what the regulations reflect is that first, if you're a charter school and you're not using the facilities solely because the charter petition has not been renewed or it's been revoked, you still have your normal procedures where you're going to be able to, make sure that everything is right there. So it's not taking away any steps as far as any appeal rights you might have if your charter petition is not renewed or revoked. So that step stayed the same. But in that next step, so once we get to the point where the charter is no longer using it for their purposes, whether voluntarily or involuntarily, it goes to another qualifying successor charter school. And right now in both sets of regulations, that's about what it says. And we're learning at this point that we might need a little more specificity in those regulations to be helpful in how that selection process occurs. And what OPSC and CSFA are looking to do here is make sure that the process that is used by the state and districts to identify that successor charter school is fair, that it's transparent, that it's made available, basically, that folks know about it. So we don't, you're not sticking a piece of paper up on the door of the charter school that's no longer needed. And if you happen to walk by, you might notice that this facility is available. No, we're looking towards more of a broad notification type process. But basically, we're trying to just make it fair and open to as many folks that could be interested in as the facility as possible, and making sure that that selection process reflects what's in the statute for providing preference for schools that are to receive the charter school funding. So that's the intent behind these regulations. Michael, if you could scroll down for me to the beginning of the regulations, please, which is past the authority section on page 4 of 19. Yep, right there. So These are the OPSC regulations. We have the CSFA regulations as part of the item as well. So this language is it's mirrored in both entities' regulations, and there are a few things that CSFA will address on their regulations as well. But what we did here is we built the changes into the existing format. So you'll see right there in underneath section A, we have now got a section A1. So before the qualifying successor charter school shall be permitted to occupy the facility. So that was all it said. And then after that, it jumped right down to section B, which basically says if there is no successor charter, then the school district can choose to occupy the facility. So the new language is all there in section A, and it outlines a process that will be used to select the next charter school. Now, we do realize that it's not going to be the same in every school district. There are some districts where there literally might be one other charter school. So if you call them up and explain the situation, then that could be considered sufficient as far as notifying. But there are some school districts where there are 100 charter schools that could potentially be interested in this facility. So we recognize that the process could look different depending on where you're at. So these regulations are intended to ideally allow that flexibility for the different circumstances. Now, there are a few things that that are pass-fail basically in this process. You have to be a classroom-based charter school because that's who these facilities funds were for originally. So that's something that's part of the program that has to carry forward. You have to be found financially sound because that's a requirement of the program as well. So there are certain things that have to come into play in this process. And then there are things where there's preference. So we've outlined in here, and actually in the cover item, that we from the state perspective, we're using the preference that is provided in the statute for charter schools that serve low-income students and charter schools that qualify as a not-for-profit entity. So those are two things that are in the statute that guided the original funding that we've carried forward in these regulations. So you'll see there in A1 some clarification too. So who is responsible for finding the successor charter school? Well, the state has a role here, and then the school district has a role. Now, sometimes there are two school districts, might have an elementary and a high school district that serve that same geographic location. So when we're looking at things for charter, when we're looking at these projects, it's the school district that would be responsible for the same grade level of students. So if this was an elementary school charter and we are in an area that has both a high school district and an elementary school district, then the elementary school district would be taking the responsibility of working with the state to find the successor charter school. So that's consistent with other aspects of the charter school facilities program as well. So that identifies the district. And we've put in here language that speak to publicly notifying all eligible charter schools that are authorized to operate in the district's boundaries. So that section right there, this is the part where we want this to be open to as many charter schools as might qualify. This is the transparency piece where everybody has a fair shot at obtaining these facilities. So what that public notification looks like, that's the part where that could take different forms depending on what school districts typically do. So we're just looking for some sort of public notification. These facilities are available. The eligible charter school qualifications here, we've outlined some of the things I just spoke of, the classroom-based, financially sound. We've included in there that they need to be able to assume payment of the funds that are still owed. So a lot of these facilities are still going to have that 30-year loan on them or a portion of that 30-year loan on them. So this is not a free facility if there is still a loan obligation outstanding. So that piece ties into the financial soundness determination. And we do have the charter school agreements. The successor charter needs to be willing to enter into those charter school agreements as well. And then also because this is a joint responsibility between the state and the school district, the district may have additional requirements that could be included in there. For example, in section A1A there could be some situations where particular grade levels don't work. So maybe it's a co-located site and it's an elementary charter school, but they have to share some facilities, and it's a high school site. So maybe there's something that just doesn't work out there with that. So there could be some limitations on that. And there could be some district limitations in Section B if local funds were provided to construct the facility, like perhaps local bond funds were used. Those bonds may have had specific requirements, and we don't want to put a district in a position of violating what their voters were expecting as far as how those local bond funds were going to be used. So that's something that could be factored in there as well. So that gets into sort of, those are your light switch things that where charter schools need to sort of meet these criteria to be willing to participate in that aspect. And then in number 2, section 2 there, so A2, we get into the situation where, well, okay, everybody's been notified, and now we've got more than one charter school that meets these minimum requirements that would be interested in this facility. So how do we pick? How do we decide who gets that facility? And the language here speaks to wanting this to be a fair process and competitive process, and that is consistent with, again, how the original funding went out. And so we've included language in here that there's basically going to be preference points or a ranking system that will allow for the applications to be evaluated and compared in a way that's fair, basically. We did include that the preference for the low-income students and the nonprofit entity needs to be in this ranking mechanism that's used. Low-income students in this program, it's determined by the percentage of students that are eligible for the free and reduced price meals. And the nonprofit entity, that is the definition that it's an existing CSFP regulations. So these are your 501c3 organizations or your nonprofit public benefit corporations. Again, just keeping it consistent with the program as it is now. We also added some language in here that the combined total eligible points or weighting provided by any additional district categories cannot exceed the low income and nonprofit categories. So there's going to be any number of ways that these processes can be scored, but we want it to be fair, fair in considering districts' considerations and fair in considering the state's considerations that we're bound by as well. So the free and reduced lunch percentage plus the nonprofit cannot equal 10 points, while other things the districts put in there equal 90 points, for example. We'd like it to be equal, and there's any number of ways to get at that. So let's see, then we have listed in A2, A, B, C, and D examples, and this is including but not limited to, but these are some examples of categories that a district could use to add additional preference when they're selecting successor charter schools. These are some things that we've heard from districts, and again, not an exhaustive list. When we're looking at this, we'd really like to work closely with districts to make sure that the state and the district are on the same page on what's acceptable, but these were things where it made sense. So health and safety issues, if it's going to resolve that, then that's a great use. Getting charter schools out of a non-school property into this facility could be considered, because then they're in a Field Act compliant building, which is a nice thing according to the state. The same grade level makes a whole lot of sense to us because the building was constructed for a particular grade level. So it has its CDE approvals for a particular grade level. Its potential, if it's co-located, that's been a factor. So grade level we thought was a good example of something that a district could choose to provide additional priority to. That is also consistent with the legislature's desire to try to spread the funding out between various grade levels when we issued it the first time. So keeping it at the same grade level is consistent with the statute there as well. And then some other factors, thresholds or percentages of in-district students or unhoused students, and that ties to how we administer the school facility program as well. So when we're looking at enrollment for purposes of building facilities within a school district's boundary, we look at the enrollment for that district. So that seemed to be one that was coming up for districts that was important, that there be some way to not necessarily eliminate a charter school that's serving a large proportion of out-of-district students, but to maybe put some preference to schools that are serving the students where this facility is physically located. And then let's see, moving on to number 3. Basically, it's just that the district and then the district's going to identify the order based on the points, and that's how that successor charter school is going to be selected. And it's in ranking order because if you get 20 folks that apply, you want to have that backup plan in place, right? So we've got 20 folks that apply. Here's number 1, 2, and 3. We're going to start working with person number 1, but if something happens and they change their mind and they don't want to enter into agreements or something like that, then number 2 is already selected. So it just kind of helps with the process there. And then that is really the bulk of the changes, because the next edit to the regulations is just a lead-in, and it goes back to what's already existing in regulations today, that if there is no qualifying successor charter school that wants the facility, it just goes back to the school district. And then if the school district doesn't want to take the facility, then they have options to either dispose of it under surplus property, or if the district doesn't want to do that and they're not holding title, then the state will take care of disposing of it under surplus property. All of those sections were already in the regulations though, so that was not a change. We're really just adding clarity, hopefully adding clarity to how to choose a qualifying successor charter school. With that, before I go too much further, I wanted to turn it over to Katrina to see if there's anything that you would like to add there, or if you wanted to mention you or Michael wanted to mention any of the.
No, just for ease of reference, we just, are utilizing the same language and cross-referencing the SFP regs in our definitions. So, I'm just curious to hear what folks have to say. I see Nick on the line and some other stakeholders that we've already been, talking to, who have expressed interest in this particular issue. So I thought you did a great job. Thanks, Barbara.
No problem. Before we get to any comments, can we start with anything that maybe is unclear? If anybody has questions on any of the steps we just covered, so that we make sure we're all starting from the same understanding. Did that make sense, kind of what we're trying to do, or any questions on that part before we maybe get to the specific language or suggestions for change? And again, feel free to use the raise hand feature if you'd like, and we will call on folks, or if that's not working, just unmute. Sue Ann, please.
Introduce yourself and say where you're from, maybe.
Sure. And let me start my video as well. I'm Sue Ann Evans, and I'm legal counsel for Inglewood Unified School District. I wanted to, just as a clarification question, the nonprofit piece that you referenced as part of the original statute, I think you said, Barbara. Can you clarify which statute you're referring to?
Yes. Hang on one second. Not sure if we included it in the item because it's actually in a different section. So give me just 1 second, because I'm currently using my EdCode to prop up the laptop. Hang on 1 second. Erin, if you have it, jump in. Okay, it is 17078.56B. So it's going back to the original preference that was provided. And it states that, well, there's a few sections before it. So it's talking about spreading it out through the geographic locations, the various grade levels, the urban, rural, suburban, et cetera. So it says that while ensuring the requirements of all of those things are met, that when considering all approved projects under this article, as a whole, the board shall, within each factor of the criteria set forth in subdivision A, give preference to charter schools in overcrowded school districts, charter schools in low-income areas, charter schools operated by not-for-profit entities, and charter schools that utilize existing school district facilities. And actually, that's a great question to segue into something else, because we did not use two of those categories because they don't work with this step of it. So we did not use preference for schools that are using existing district facilities, because that really came down to an initial step where a charter school was deciding if they were going to do rehabilitation work on a 15-year-old or older school district facility, or if they were going to build something brand new. And that's not really a factor right now because the school's already been built. So we didn't put that one in there. And then the overcrowding, that was also a first step process to where school districts could provide a certification to the number of unhoused students that the project would serve if it was new construction. So we didn't put that in there as a direct translation, but we did use that as an example of something that in these regulations as something that a school district could consider for additional preference. And that was in that section that spoke to a successor charter that would serve in-district students or unhoused students of the district. So there's a slight nod at that. It doesn't directly translate when we're looking at a facility that's already in existence, but there's a little bit of that piece there. But that is where that comes from. So 17078.56B.
Thank you.
And Barbara, all those went into creating your funding matrix.
Yes. Yeah. So all of those are in it's a very complicated matrix, right? We fund through 4 different regions, 3 different grade categories. So we go in order. I think it's 11 total categories. I'd have to count it. It's been a while since we've done a round, but yeah. So when we start the application process, school applicants receive points for their project using those 4 categories. So you have a total points value assigned to the application. And then we use the other section where, okay, so we're looking at geographic location. So we're in region 1. So of all the applications in region 1, the school with the highest number of preference points gets funded first. Then we move to region 2. Then we move to region 3. So you take the highest applicant within each of those prior categories.
Barbara, I have a follow-up question on that.
Yeah.
So because the Ed Code prevents operations for for-profit charter schools, I'm trying to understand the nexus with including this language, because could nonprofit also mean dependent charter schools, although that's also not specifically defined in code, dependent versus an independent charter school. But I'm trying to understand why a nonprofit status would be, used in this way.
We didn't write the law, Debbie, but our understanding is that because traditional public schools, which include dependent charters, can access funding through the state's SFP, they tried to tailor this program for independent charters because they cannot access SFP. But if Brian Holman wants to weigh in, or any other lawyer, or John Lemo regarding, yes, dependent charters are governmental entities and therefore nonprofit. But that distinction between not being able to access SFP kind of set apart for this program the independent not-for-profit charters. But Brian or Mark or John, did you want to weigh in on that?
I'll weigh in too, Katrina, because we did look at this for some of our past rounds, and our legal counsel did determine, or we were not able to find a way to consider a dependent charter as a nonprofit entity because it doesn't carry the same status, the same nonprofit status. So Katrina is spot on with why that comes into play and how that actually comes in the program, because we have had cases where the nonprofit points do make a difference in whether or not that school is going to receive funding under the CSFP or not. So it doesn't preclude a dependent charter from coming in under the CSFP, and we don't believe that these regulations would preclude a dependent charter, but it does provide priority to those independent charters that have that nonprofit status. I'm sorry, I think somebody else started to speak. I apologize.
No, this was Brian Holman. I don't have a comment on the nonprofit entity. Generally, government agencies are considered nonprofit, but I accept your explanation here on that. I do have a bunch of other comments about the regulations, which I circulated yesterday in letter, and I hope you received it. And I don't know if you want me to repeat that or for the group, or wait till later in this program.
We can start there if you want. Suan, did you want to stay on that topic before we move to something new, or?
I would like to stay on that for a moment. First, we haven't seen the comments that were submitted, and I'm wondering if there will be an opportunity for all the stakeholders to submit written comments, and then how those would be shared. So for example, Brian, I haven't seen your comments on the nonprofit or other piece. So I'd just like some clarification on that first.
Yeah, so what we've done in the past on the stakeholder comments, and we try to incorporate them into our next item. So, but because we just got them yesterday, obviously we're on some shorter time frames here, but because we got them yesterday, they didn't go into the original item, as in addition, they were response to the original item, right? So we can discuss those here today, but then what we will do for the next item is summarize the comments that we hear verbally, as well as the ones that come in writing. So comments made in this meeting today are totally fine. That is a completely acceptable way to provide comment on the regulations. Folks can also write in either email or letter. That's fine as well. And then on the OPSC side, what we do when it ultimately goes to the board, so you'll see it in the stakeholder items, but when it ultimately goes to the board, what we have done in the past, when we're presenting it to the board, our write-up includes a section of comments that were raised by stakeholders that were accepted and addressed in the regulations. And then if there's anything that we did not accept, then we put that in our write-up as well, just because we want our board to have access to all of the information. And it will include an explanation as far as why it was not addressed in that particular regulation set. An example, I'm trying to think of an example that, for example, if we don't think it's consistent with statute. So comment X was not included in the regulations because it's inconsistent with a particular statute. And so, or because of whatever the other consideration is. So either way, the comments are made available to the board. Now we might summarize it a little bit, but we do put our board item out a week in advance of the meeting. So if folks don't feel that we've accurately captured it, you still have another opportunity to let us know or to weigh in at the state allocation board meeting or the CSFA board meetings as well. So it's kind of a process that we've used in the past, but yeah, verbal's fine, written is fine, whatever folks are most comfortable with. There are no other questions on that. Brian, did you want to start with some of the comments that you raised in your letter?
I'd be happy to do that. Thank you. My name is Brian Holman. I'm with the law firm of Music, Peeler, and Garrett. My practice consists primarily of the representation of charter schools in connection with facilities finance, and I have represented several charter schools in connection with CSFP projects and have heard from several of them in connection with these regulations. I want to start by saying that there's nothing in the statute that reserves or delegates to the state a role in the selection of a successor charter school. And as I will explain, I think there are reasons why perhaps that selection should not be vested exclusively in the state or the school district together, depending upon how the project has evolved. From the standpoint of the state, they are a grantor of the grant portion of the CSFP award and a lender with respect to the loan portion of the CSFP award. And typically, I would say the grantor of a grant doesn't retain authority over the subsequent transfer of the property that's the beneficiary of the grant, and the lender doesn't typically retain the authority to decide who a subsequent transferee of the property might be either. Where a grant has a restriction on use, such as here, where the property can be used only by a successor charter school that meets the eligibility requirements and passes the financial soundness test, typically the grantee would say, I control who the successor is, they just have to meet those standards. And the lender would say, as long as the successor is creditworthy and meets my financial soundness standards, I will consent to the transfer. From the perspective of the charter school, and here I'm going to use as my example a charter school that has is the awardee of the grant and also holds title for the benefit of the state public school system, subject to the so-called state lien. So we'll keep the school district out of it for a while. The charter school views itself as the owner of the property, in which a portion of the cost of building the facility has been funded by the state pursuant to a grant, and a portion has been funded all or own. And the charter school may well, and actually usually has to, invest its own funds in the project, because the way the CSFP program works out, it doesn't fund fully the cost of the projects that the schools desire to build. So you have typically at least three capital sources. You have the grant, you have the CSFP loan, and you have a private investment. And in some cases, the charter school might decide, for whatever reason, not to take down the loan or not to take down all of the loan. And so perhaps there's only a grant and the charter school has funded the balance of the investment. The charter school now perhaps is facing an inability to operate at the site because, as in the case of one issue before or pending right now, the charter school hasn't been able to maintain enrollment as it expected, or perhaps it has financially failed, or perhaps it has done neither, but its charter is non-renewed for reasons outside its control. And it now is holding a piece of property with a substantial financial investment on its part, and these proposed regulations don't retain or reserve any role for the charter school that has made this substantial investment in the property to recover that investment. Theoretically, the charter school would like to sell or transfer its interest in the property to the highest bidder so that it can recover the money it's put into the project. There's no room for that in these regulations. There also might be other financial arrangements or facility arrangements that require a different process here. In the case that I pointed out in my letter of El Sol Science and Arts Academy of Santa Ana, we have a complicated structure where the charter school is subleasing the CSFP facilities that are a part of an overall complex with privately funded facilities, and is subleasing them under a single sublease, where any assignment of that sublease is subject to the consent of the sublessor and its lender. And these proposed regulations appear to supersede the provisions of the sublease regarding who can occupy the property, and don't take into account the fact that the charter school that takes over the CSFP funded facilities can't really operate without the rest of the premises. The CSFP funded one classroom building, and I believe the administrative buildings and many of the other buildings necessary to operate the school were privately funded. And you can't, really have two separate charter schools. Neither can operate without having the control of the entire complex, and that requires the consent and involvement of these third-party lenders, who, when they made their loan, expected that in the event of a default, they would be able to find a successor to take over the role of the charter school as subtenant, would go to CSFA and OPSC and say, here's my proposed successor charter school. Please certify that they are eligible and meet your financial soundness test. And once you do that, then we'll be able to carry on and hopefully our loans will get repaid. And the regulations don't account for that sort of a circumstance either. So I think my overall perspective is that what has been proposed works fine if there's no one else that claims an interest in the facility and it's been abandoned, and then the state and the school district together need to work out who will take over the property. But where there are material financial interests of third parties, such as the charter school if it's made a financial investment, or lenders if the facility is part of an overall financing or facility scheme, we need to account for their interests. That's it.
Great, thank you for sharing. We will take that back and take a look at it. I think there's a couple different things going on there that we will want to take a closer look at. We do appreciate the feedback on that. One question for you, though, going back to, you don't feel that the state has a role in selecting a successor charter. So then is your opinion then that it is the school district that selects the successor charter?
I'm not saying that the state shouldn't have a role. I'm saying that the statute doesn't require it or expressly reserve the role. I would argue that the initial selection should be made by whoever holds legal title to the property, which might be the school district or a charter school, depending on the arrangement. And in the ordinary case, they would come to OPSC and CSFA and seek consent to the transfer of their interest to the successor charter school. Now, I recognize maybe we need a balancing here of the interests of the state and of the departing or exiting charter school, but the proposed regulations, leave no role for the current owner of the property or their lenders to have a say. So, I don't have a fixed answer here, but I think the regulations don't work in all cases.
And then one more follow-up question, because there are provisions in Ed Code for significant contributors, but it ties it to the step when the facility is disposed of, as opposed to this earlier step on the qualifying charter school. So that would be something that we'd want to take a closer look at, because we can't write a regulation that is doing something different than what the law says as far as significant contributors. And we are reading that the significant contributor role comes in if the site is going through the process after the successor charter is there, after the school district decides they don't want it, and it's actually being sold through the surplus property provisions. So that would be maybe something else if you wouldn't mind taking a look at that as well, to see if we'd like to get your thoughts on the interaction between that statute and what you're proposing as well.
Yeah, I have taken a look at that. Now, No, go ahead. I haven't thoroughly reviewed it, but my recollection is that the statute basically says you can't fund your local matching share with secured debt if there are costs in excess of what the CSFP award funds in order to fund the construction of the property. You can have a deed of trust that secures those excess costs, or a loan to secure the excess costs. And you're correct that that loan to secure the excess costs gets repaid when and if and only if the property is no longer used for public school purposes and the property is sold, which means that no lender in its right mind is going to take that deed of trust, because under California's debtor-creditor rights rules and one action rule, the lender could never enforce its loan. But there's nothing in the regulations that prohibits the school from borrowing on unsecured basis or investing, its money or its donors' money in the project instead of, or to fund the local matching share. And those could be significant dollars. And if those dollars are left behind or have to be abandoned, if the charter school can no longer occupy the property, it's a huge financial hit to the school. And in the event the school is closing, for example, because of financial difficulty, it might need to recover as much of that as possible to pay its creditors. So to have regulations that suggest that if the charter school no longer seeks to occupy a property, it must abandon any investment it's made seems a bit harsh.
Are there other thoughts on this topic? Other comments, questions?
This is Mike. This is Mike Keeley. Can you hear me?
Yes, go ahead.
I think I just want to echo Brian's point that CSFP in the markets that we work in does not cover the cost of the project. There is a gap that has to be filled. The only way you can fill the gap is secured debt or donor money. And you're right, the regulations draw a distinction between the match of the CSFP versus cash that exceeds the CSFP award. But in every case Brian and I have worked on, the amount needed to build the project is more than what CSFP awards. So if we're consistently dealing with this situation where we need more than what we get from CSFP, how do we create scaffolding where the providers of that capital know that they will be respected in the situations we're facing? Thank you.
Thank you for your comment. I will point out we have other provisions in the program for the SFP. It's our financial hardship program where the match is basically the state has its 50% or 60% share, and then the local match is not often, but sometimes covered by the financial hardship share, and it sets a hard budget. So basically, if a school district has no funds to contribute, then the funding formula that comes out from the state project is the cap. So I don't know that it's always the case that the project can't be built with outside funds. We have seen a number of schools that were built within budget, with savings even, both in the charter program and the school facility program and the financial hardship program. So it's something to consider, but pointing out that it's not every school, I don't believe.
And I represent one school which has a CSFP funded project, and I don't know if they fully funded that project or not with the CSFP funds, but the land on which the project is located was purchased with the CSFP funding, and the school is attempting or is building a gymnasium on the site, or a multi-purpose building. We don't call them gymnasiums anymore. And they, because it's on the CSFP land, they could not obtain secured credit for that because you can't really have a security interest in the property. But they have privately funded this additional investment in this multi-purpose building that was not part of the project for the original award. Let's say that, I don't know what a multi-purpose building costs, but let's say it's a couple $1 million. So now they're going to invest their own millions of dollars into building an additional building on the land. And if the school were to have its charter non-renewed, how do they get that money back?
Yeah, we'll have to take a look at the concept of the additional funds that are put into these facilities. Katrina, you can feel free to jump in too, but just initial thoughts are that the state program may not contemplate that, even from a statutory standpoint. So we'll take a look and see if there's any room there to allow for something else in there, because I think the the program structure is really set up to just ensure that the facility remains a charter facility, and then it moves over on equal terms from the prior school. Equal terms from the state perspective on that would be equal terms that we've had on the loan. So we'll have to see if there's room there to amend to incorporate this outside of the significant contributor language that is not until the disposal section. So we're happy to take a look, though.
Thank you.
Sue Ann, do you have a hand? You have a hand up? I think this is new comment.
I do. Well, I wanted to go back to the issue of sort of who's intended to what the facility is intended to house. I know you said you took out reference to the in-district student preference and gave a nod to it. Basically in subsection 2D, we'd like to see that moved up into the main preference without it being something that the local district would have to seek an approval from OPSC or CSFA. And then I don't know if anybody else has a comment on that, but we'd like to also understand what the process looks like for that approval. There's nothing in the regulation that speaks to how the district would go about getting approval for additional preference points. So we'd like to understand what that looks like.
Yeah, I think that's going to probably be dependent on the circumstance. So we have an example that we're working through now where the district is using it feels like an RFP style process. So it's just been sharing of information and kind of a back and forth there, but it's not been an official, like there isn't like a form that's been submitted, anything like that. So we've just been keeping it sort of, I mean, we haven't had one of these in 19 years. So
you have two.
Now we have two, right? So hopefully this isn't a continuing trend, but we're not expecting, tons and tons of these to come through. So we're hoping to leave a little flexibility in the process to where it is not so set in stone that it has to be done a particular way, because we may inadvertently make it harder for districts because we can't contemplate every scenario, but we would be open to I guess we could set something like a notification, but I think in one of the cases we found out about it kind of randomly, and the other one, the school district notified us. So there's just different ways that the state is finding out about these facilities. Now, obviously our agreements do include language where charter schools are supposed to let us know, or applicants are supposed to let us know if there's been a material change or if things, have happened. So all of that language is in there. But at the end of the day, we could write more language like that as far as, the district's going to notify, et cetera. But I don't know if it's going to work because we should have known on a couple of these.
Well, fair enough. And I think the district would appreciate that flexibility that's intended. So if it's just a matter of sort of being in communication, that's great.
That's where we were at with it. But if folks are looking for more of a structure, I think we're open to that too. But that's why it's not in there, is because typically when these things happen, this is a huge deal for a charter school to close and to not use the facility. And so it hits the radar. So typically usually it hits the radar before, payments are missed, things like that. So usually we're getting a contact from the charter school or the school district, or it is something where the state is just aware of it. So I don't think we're going to miss one. But yeah, it's, I think we'd like to, we can look at it, but I think we'd like to leave some flexibility in there.
Okay, fair enough. I think the more important of those two issues that I just raised was the need for a preference for in-district students. That question of a threshold. I mean, really within the district boundaries, the facilities should be used for in-district students. So we'd like to see that be a primary preference into, section A2.
So
I don't know what the threshold would look like, but that's something that we would think is very important.
So the including but not limited to language, so when we specifically called out a few that we knew would be like acceptable to the state. So that's why we've put those ones in there. As far as the health and safety and the threshold and the
I think the concern is that if it's in that subgroup, it doesn't have the same import with that limitation on the points that can be allocated for that preference can't be more than what's in 2A or A2. So that's really something that we feel should be looked at almost as a number one priority. Who are the students that are going to be housed in that facility?
Okay, we can take a look at that. One of the things that we have to be a little bit aware of, the program itself doesn't limit it. So if we have a county authorized or a state benefit charter or a state board approved charter, all of those applications are treated equally when we're awarding funding the first time. We have nothing in statute that allows us to only provide funding to the school districts where the project is for in-district kids. So that's something that we'll have to weigh, is that, and I think we've had a whole mix of projects over the years. So I think that there's a little bit of concern.
To that, are they housing unhoused students and that piece of it? So I think there's a connection to how it impacts available housing for district students. And certainly with districts being required to provide facilities under Prop 39, it sort of all ties in.
Yeah, and I hear everything you're saying, but even on the unhoused students back, was it Prop 1D? So Prop 1D took away the requirement for the eligibility piece. So basically projects could move forward without housing any unhoused students. So that section of the law changed a little bit with the districts certifying to that. So there, I think we do have cases where there are new construction style projects that are not necessarily relieving any of the unhoused students for the district, but it still allows the charter to move forward in that particular location. So yeah, there's a lot of, there's been a lot of back and forth in the program on this, on what students, and so that change came about because districts didn't want.
They weren't doing it.
Well, I mean, when you have to, yes, there were some things there, obviously, getting your foot in the door on the program. But also the concern was, well, it's not even housing our kids. These are kids from out of districts. So I don't want to say that this is going to cover all of my unhoused kids, because it's really not. The charter is operating 50% in district, 50% out of district. So I'm only going to certify that half of these kids are coming from my unhoused students. So that piece has been looked at in the program, but there's no hard cutoff.
No, right. And I understand this is just a matter of a point system as it's proposed. So a charter with a significant district in-house number, pupil count would perhaps get more points than one that did not. So I don't see it as a yes or no, but as part of the calculation, but an important part.
Okay, we'll take a look at that.
Thank you.
Let's see here. Debbie, I think your hand is up.
Yes, thank you so much. And make sure I turn the hand down now. So I concur, especially in areas like Los Angeles where, space is limited, where, in-house students need to be, prioritized, if you will. So, I agree and think that is an important factor for consideration is in-district kids or in-boundary kids as part of that primary consideration. And I have another question, and it's about, and I think early on in the conversation there was something that sparked my interest, and that was, maybe a joint use for a district with district authorized charter schools. I know we have a couple that are small, maybe in good standing, but maybe because of their size would not be eligible to take over a sizable loan like what could be proposed, depending on their own financial situation. Could it be, is there another opportunity, because some have actually reached out to me and said, is there an opportunity here for some kind of a joint use with the school district and its authorized charter schools? And I don't see anything, or maybe I missed it, but is there anything in these regulations or prior regulations that would potentially address that as being one other option?
I don't think we have anything specific to this in the regulations. I know the state didn't have any objection to two charter schools occupying the facility, provided that it didn't cause any problems as far as, it met all the other requirements basically. So the two schools that were sharing it would be able to make use of the facility in a safe way and still be subject to all the other requirements. It wasn't something from the state level that we had any sort of preference on as far as statute to draw on or prior regulations, but I could see that being something that would fit into a district's preference, where if you want two schools to share the same facility, just because you get 2-for-1 out of that, right? Two schools now have a home. So that could be something where a district could provide preference to applications for the facility that would house more than one school. Katrina, do you have any further thoughts on that? Because we did kind of touch on this a few weeks ago.
We thought there was a kind of, again, we're the state, not the district, but we thought there might be kind of a highest and best use, but then it led to a conversation about complications, i.e., one school no longer needs the facility or can no longer afford it or closes. Then there's that bag. And so, yeah, it felt, kind of neater and, kind of mitigating extra risk, if you will, to just have one school. So, that might be in a situation where you have one borrower with two schools, where that risk might be mitigated. But that's kind of some of the complications that we discussed with the district.
I appreciate that, and thank you for that answer. It could also provide the state with extra security, as opposed to confusion between the charter schools. But if two were in there and they both had some financial backing, it could provide some extra assurance too as to the payment. A third and last question, unless I think of more, is what if, how would it work if there were balances due the state and other program areas for the original program charter school that left the building? What if there were amounts due the state under, say, OPSC or maybe under other grants that were due the state? How would the state recover its funding? I think my question goes back to, with one of the speakers, Brian, I believe, that talked about maybe some of the private vendors that had loaned money, but what about the state? Is there anything in regulation that would provide that, anything due back the state would also be repaid as kind of first call?
I think a lot of the state's protections are built into the agreements. So we have leftover loan, right? So in some cases, the charter school has probably stopped paying the loan payments. So we need to recover the loan funds. The state, we need to make the bond funds whole. So if there was $9 million left on the loan, then part of equal terms on the project would be taking over the remaining loan amount. So I think that's something that we feel is covered under the equal terms section of the regulations and the agreements. And if it's related, it would have to be related to the CSFP pieces. So there wouldn't be, like, we wouldn't be recovering on something that was in general, like a different state program. It would have to be tied to this particular project. So I think we were thinking that equal terms would capture that.
Perfect. Thank you so much.
I'm looking for other hands here.
My apologies. I did have one more. And
Oh, no, keep going.
in terms of notification, I'm so sorry. Normally with notification procedures, there's usually some like guidance around that notification. Like you have to put it in a paper of circulation for 2 weeks, and another 2-week period of time or something like that. Was notification can mean a lot of things, and so I'm just wondering, what would that notification look like specifically? If we notified all eligible charter schools, would that be one notification? And what would be the time period for response and things like that? Is that part of the regulations, or is that something that we've thought through?
That's a good question. Yes, we did include just some language in there that it needed to be publicly noticed and a fair and competitive process. We didn't go too much deeper than that because we thought that it might look different depending on each school district's typical process and also just the number of charters that you're working with. So, if you send a letter to one charter school and that's the only classroom-based charter you have in your district and they respond within 2 days, then maybe you can move forward. Whereas with 100 charter schools, you might need a 30-day process or a 2-week process. I don't think we're opposed necessarily to looking at other notification procedures, but the reason that it is not nailed down further is because we were trying to allow flexibilities for different circumstances. That's been part of the sticky point of trying to figure out what this process looks like, because it is different in every district. So we are trying to find that balance. But if there is a general consensus from folks that they'd like to see the notification procedures developed a little more fully, that's something we can look at as well. And please don't apologize for the questions and the comments. That's what we're here for today. So keep them coming.
Hey, Nick.
Whoops, sorry about that. Good afternoon. Hi, Katrina. Hi, Barbara. Thank you for all this work. I know you all are trying to make good program improvements, and you're trying to do it on a somewhat expedited time frame so that particularly the one school involved can get resolution and have a new operator in place by the fall. So thank you. Really appreciate that. We submitted a comment letter. I sent it right as the meeting started. You probably haven't had a chance to review it yet. I would say, just generally, I echo a lot of what Brian said, and I would just encourage you all, primarily, I wanted to raise the issue again of diverse project models and how charter schools use a variety of different approaches and different funding and financing mechanisms. And, school districts, if we're talking about a school, it's built on a district site and the district has provided funding through the local bond program or some other way to help the charter school build a facility, then obviously they would have, the district should have, a lot to say about how the property should transition hands to a new charter school operator. I think in a case where, a charter school site that's not owned by the district, where the district provided no funding, and where the charter school has, used private financing sources or philanthropy or other things, is a very different scenario. And I would hope there could be some flexibility built into the regulations to just acknowledge that and to help
So
schools.
Nick, my concern is, and I don't, for all the lawyers on the call, we can't put anything in regs that negates or conflicts with law.
Mhm.
So, we might want to, giving you, obviously, we don't go into the Capitol and advocate. That's what you all do. But, we're happy to work with you on, if you wanted to look at a legislative change, or at least on the bill going forward, maybe that's a neater way to do it. But I agree, when there's really no district involvement, to have the district in line for secession is, there was obviously a reason for it, but I think that's something that Barbara and I and the team will talk about.
Thank you.
So as you know, the two fact patterns that we're looking at right now have, pretty heavy district involvement. So.
Yeah, I appreciate that.
Barbara, I don't know your thoughts on that.
No, I agree, kind of in the same line that, when we're looking at that, we would have to look at what the statute already says, and if there are, like, we typically can't add provisions that weren't already outlined in the statute. So, and I think probably the program has evolved, and, we're further along in the charter movement, even just, in the past 19, 20 years. So it may be something that, like Katrina said, is worth, the legislature taking a look at if there was substantial contribution there from the charter school. There are, I think, a lot of different ways that could be looked at, but yeah, we're happy to see what we can do within the existing statute.
I raise my hand only to say it's not clear to us where you can operate within existing statutory framework and where you need new statutes. So we'll need direction or input from you to figure that out. If you can work this out without additional or new statutes, great. You don't need us. But you're right. It's not your job to go to the legislature. It's our job. And but I don't, it's not clear from this conversation whether we have to do that yet. You guys have to tell us if that's needed.
Yeah, I think, Mike, if we want to sit down with Brian and Nick and the other lawyers, we can look at that. But, districts are in the line of secession. And as you know, when it's a facility is on a district site, they're a party to agreement. So, I think that's where, kind of creates a set of rules outside of the statute being the CSFP Act. So happy to have a separate call or smaller working group on that. Mike, did you send in comments? And Brian, because I was pulled on a matter here, unfortunately, when I heard you and Brian speaking. So
I hope you received the comments. Brian did send comments in.
Okay.
You should have received comments from CNCA, one of the two schools that is.
Yep. We've seen those. Yep.
Yeah, I'll send them to you, Katrina. I think I just sent them to the other, Michael, Barbara, and Aaron. My concern, we are where we are, but going forward, these regulations are going to establish a pattern. So if the regulations come out and say, in the event the charter school no longer wants to operate the property, it will lose or must forfeit its investment in the property, then, that's going to affect how people use the program going forward. They're, I would think, less likely, and donors are going to be less likely to want to contribute to a charter school's capital campaign.
Mm-hmm.
If
Barbara
the
and I
funds
looked
that
at
they're
that
investing in their school could be lost.
Yeah.
If the charter is non-renewed, and that might limit the use of the program to facilities that can be financed wholly within the dollars that are being awarded.
Yeah, and we know that's hard to do. Barbara and I looked at that language yesterday, and again, that's at the statutory level, Brian. So we might want to put that on a short list as well to talk about offline.
Were there other comments, questions? Check the chat here.
Thank you for doing this.
Yeah, absolutely. Yeah,
It is much appreciated. Thank you.
we really appreciate you guys attending. We really
Yeah.
value the stakeholder input, and you've taken time out of your day to be here, so thank you. And
it's not lost on us how significant this matter is, particularly given that, this program is very mature now. It's an adult. We're going to see more and more of this. So, we do really value collaborating with all of you, to come up with some resolution on how these coveted facilities are transitioned to other uses. So.
Thank you. We appreciate the opportunity to be heard and to offer some thoughts as thought partners. So thank you so much.
Thank you, Ms. Deal.
if there are no more comments, we will be taking these back and evaluating that and anything that we receive. Again, if you had further things and you want to submit them, please go ahead and just send us an email. Call us, whatever works. We're all around, so it's not the end of the conversation. And then we'll keep you all posted. So as of right now, we are still on track for Friday, March 5th for an update discussion based on what we've gotten today and what was emailed in. And Nick, I do see that I did get your document. Brian, yes, we did get your document last night, and we've got the third document as well. So far, we've received 3. There was one other district that had mentioned they'd be providing some comments as well. We have not gotten that yet, so that's coming. But yeah, let us know if there's anything.
And Barbara, I got a
go ahead.
fax from Ladera Education Institute, so I'll be sharing that with you as well.
Okay, perfect.
It came via fax, so.
Oh, nice. And then, excuse me, Michael has just put the email addresses in the chat. So if you don't already have us on speed dial, our email address is there for you in the chat as well.
Thanks, everyone.
Thank you.
Take care.
Thank you.
Thank you
Bye-bye.
all.
Bye-bye.